Okay, next I'd like to welcome Brendon Pooran, who's going to speak about rights and the law. And many of you may know Brendon already. He's been very active within our sector for a long, long time. He's been involved with various disability organizations as a member, volunteer, employee, or director for most of his life. His practice, which is built primarily around disability law issues, is inspired by the challenges of people with disabilities and what they face throughout their lives. Brendon created Pooran Law to provide a voice for this community and to serve as a resource for accessibility issues throughout Ontario. Brendon regularly provides advice to individuals, families, organizations, and government in the area of disability law. He also teaches critical disability law at York University. He sits on the Ontario Consent and Capacity Board and is the past president of Community Living South. Brendon, welcome. Thank you for being here.
Thank you, Lori. And thank you to Community Living Toronto for having me here this morning. Those were some wonderful presentations. It's going to be a bit difficult to top them, and I hope I can be as engaging as you all were. So those were some wonderful stories, some wonderful videos, and I'll do my best here to try and sort of identify the common themes, things that I've heard, and then to speak to legal rights in general. This has been a bit of a process for me because I found that, you know, I was able to, I sort of had an idea as to what I was going to talk about, and then I had the pleasure of meeting all of the panel members earlier this week via Skype, and my content sort of changed a little bit, and then every time I spoke to somebody this morning, things just sort of kept on changing. So it's been a bit of an evolution. I'll do my best to try and pull everything together. So, you know, in terms of the themes that we heard here this morning, we really heard overwhelmingly that people, that everybody wants the right to be heard, the right to be able to live, to work, to play, to reside, to earn, to marry, to procreate, all sort of based on their own choices, and with very little interference. Not meaning that individuals aren't open to support, but that's exactly what they want. Individuals are looking for supports from family members, from friends, from agencies, from workers, from people in their community. Not really looking to have their decision-making rights replaced by others. And so what I'm going to try to do here this morning is sort of provide you with a high-level overview of the law as it relates to consent, capacity, and decision-making rights. And I'm gonna try to do so in a very sort of plain language manner. I'm going to try my best not to use legalese, so please throw something at me or wave, or if I slip a little bit. I'll start by saying that you know, the laws that we have in place here in Canada, the legislative frameworks that we have in place, respects the fact that we are all equal before the law. So that's the starting point. And that's regardless of ability, disability, needs, however you'd like to sort of classify the terminology. So we've got this presumption, you know, starting with capacity, we've got this presumption of capacity. So we have an act out there, and I'll identify the acts just for people that are interested in sort of looking them up. But we have this act out there called the Substitute Decisions Act. The Substitute Decisions Act starts with the fact that people are presumed to be capable, meaning that people are able to make their own choices. And only if there's evidence to suggest otherwise, or if there's a decision that needs to be made, does that capacity come into question. So that's where we start, and you know, all of us start acquiring some rights when we're born, Those rights grow when we turn age 12. At age 16, the law says, again, regardless of ability, we have the right to make all of our own choices with respect to personal care, all of our personal care needs. And personal care includes health care, shelter, hygiene, nutrition, and safety. So with all respects of our personal care life, we have the choice to make our own decisions at age 16. At age 18, we're presumed to be capable of making choices relating to all of our property and to the signing of contracts and to making a will and to appointing people in our lives to support us by way of powers of attorney. So that's where the law starts, and I know that this comes as a surprise and in some cases a concern to parents and other family members out there that you know, and understandably so in some circumstances, because nothing really changes as people for some families in terms of the supports required to assist their son or their daughter or their family member in terms of making choices. Nothing changes when the person turns 16 or the person turns 18. That same level of support is still required. But the law does come into effect, and the law says that now you know, parents are no longer custodians. Parents are never guardians of a child's property, regardless of age. But at age 16 and at age 18, the law steps in, and the law says, okay, everybody, again, regardless of ability, is able to make their own choices. So I know that comes as a bit of a surprise, and we get calls all the time from family members saying, my son or my daughter is approaching the age of 18 and I'm told that I need to do something. I don't know what I need to do. Could you provide us with some guidance? Could you provide us with some support? And unfortunately, what we've found is that there is a lot of misinformation out there. A lot of misinformation that's being provided in the legal community, a lot of misinformation that's provided sometimes from the school boards, sometimes from agencies, sometimes from government organizations. CRA is you know, one that I hear of quite a bit. Even with this new process in place to access services and supports through the DSO, often there's misinformation conveyed as well. So I'll hear comments like, you know, I'm being told that in order to access a bank account or to renew a health card, I've got to go out and get a power of attorney, or I've got to go out and be appointed guardian, or I've got to become a substitute decision maker. And all of these terms are sort of used interchangeably without the person providing the advice really understanding what they mean. And so, you know, I'll try to explain what all of those different terms mean. I'll try to explain when those sorts of instruments are required. I'll try to provide some general advice in terms of why they may not be required, and I should say that I'm open to questions at any point in time. So I'll start again with, I'll go back again to the Substitute Decisions Act, and we've got Substitute Decisions Act that sort of governs guardianship and powers of attorney, and we've got the something called the Healthcare Consent Act that governs choices when it comes to our healthcare needs. Starting with the point again that everybody's presumed capable unless evidence is raised to suggest otherwise or a decision has to be made. If somebody walks into a doctor's office, let's say, and that individual is 21 years of age, the doctor is obligated to respect that person's choice when it comes to who they want in the room with them, with regards to what kind of treatment they would agree to or disagree to, unless the healthcare practitioner thinks that person may require support. And there's this whole sort of general theme when it comes to determining capacity around the person's ability to understand the information relevant to making a decision, and the person's ability to to appreciate the reasonably foreseeable consequences of their action and inaction. So if a doctor decides, and I'm using this as an example in the healthcare setting, if a doctor decides that the person may not meet that test, that's when somebody else can then step in to support the individual. Okay, and there's sort of this hierarchy of who can step in to support the individual. So the law says that, first of all, if there's a guardian that's been appointed, that guardian has ultimate say. Keep in mind that a guardian can only be appointed by way of the court when it comes to personal care needs. So the majority of families that we work with have not gone through this guardianship process. And so in most cases, there hasn't been a guardian that's been appointed. Secondly, there is if somebody's been named as an attorney in a power of attorney for personal care, that person would have the right to provide support. In a lot of cases, we're finding that that individuals don't have powers of attorney in place, and I'll go back to that a little bit later. Third, there's something called the Consent Capacity Board that I'm not going to get into too much today, but if the Consent Capacity Board is appoint a representative. And then after all of those legal instruments are exhausted, family members actually have a legal right to step in and provide support if the person has been deemed incapable of providing consent themselves. So at the top of the list, you've got a spouse. If you're married, the spouse can step in. If not, you've got kids. If not your spouse, then kids and parents are on the same level. Okay? And then if not kids and parents, then siblings, then it goes down to any other family member. The point being here that there's no reason in the majority of cases when we're talking about healthcare for somebody to have to go through a formal capacity assessment by a professional capacity assessor, be found incapable of making any choices related to their personal care, and then having a guardian appointed to make those choices for them. Okay? So we find that unfortunately that sort of general understanding of decision making is not out there. And again, the point being that number one, it's the person's choice if they're able to make a decision. If the doctor doesn't think that that's the case, that triggers what's called a substitute decision maker authority to come in and provide consent. And then thirdly, there is a hierarchy of substitute decision makers when it comes to providing consent in healthcare situations. There's no real paperwork required as long as there's a family member who's ready and willing to provide that support. Okay, but we only get there if the person requires that support, and that's key. So whether or not there's a power of attorney in place, a lot of people will say, I've got to get a power of attorney in place. Even if there's a power of attorney in place, step one is always determining whether or not that power of attorney needs to be activated. Right? Does the person require somebody to step in to provide them with support? Okay. For individuals, for self-advocates out there, my recommendation when it comes to providing healthcare is that, and this is a recommendation I have for everybody who's able to give power of attorney, is that you do have a power of attorney in place for personal care that basically says, for whatever reason, if I can't make a decision myself, here's my choice. Here's who I want to put in place to make that decision for me. Okay, and oftentimes it may not be a family member. It may be a friend that the individual is more comfortable with. But at least with the power of attorney, individuals are provided with the choice in terms of who they want supporting them. Okay? Yes?
So as a person with intellectual disability, do you have to sign a form then to say that my mom and dad can, is that where?
Well, if they want to sort of formalize, if anybody wants to formalize who they want to put in place to support them, should they become incapable or deemed incapable, then there's a document that needs to be put in place. But even if that document, the point is that even if that document isn't there, and the individual ends up requiring support or just requires support due to due to their circumstances, there is no paperwork required if there's a family member that's ready and willing to provide that support.
If you're in an accident, you don't have any of this in place.
Well, that's the classic case, and that can happen to any of us. So if I'm in an accident on my way home here, I'm in hospital and I require treatment, the hospital's first going to say, or should first say, do you have a guardian? And the answer will likely be no. Do you have a power of attorney? Because if there's a power of attorney document, we've got to respect that power of attorney document. So whoever I've named in that power of attorney document then has the authority to make a decision for me. If there is no power of attorney document, then we get into the family member hierarchy, without any paperwork having to be in place. Right? Yes.
Jason's asking, what is power of attorney? What does that mean?
So a power of attorney, and thanks for the question, Jason. A power of attorney is a document. It's a piece of paper that allows you to make the choice of, who you want to put in place to help you should you require help. When it comes to making decisions about healthcare, about where to live, about what to wear, about being safe, about what to eat. Yeah, okay. Yes?
So what I'm anxiety about is that do the caregivers, which they don't usually know what the latest thing is, know that we as the parent have the rights, or are they going to turn to us in emergency say, my child is not verbal, say he is. Well, I'm not going to treat you, you can't come in the room because he's a 19-year-old and he has the right to have no one here or whatever. Well, they don't know his situation. I have no way of proving his situation. So how can I expect the doctors to know this is the way it is? Because often as parents we come across people every day who know something that's the way it was 10 years ago and they haven't updated. And it's us as parents, well, you're just a parent, you don't know how this works. When really, we do, we're here, we do have the most up-to-date information, and we're in an emergency situation, or just a regular appointment, or with new doctor that maybe not,
sure.
The dentist,
yeah, and I understand that frustration. I mean, the healthcare practitioners have a legal obligation to determine whether or not somebody requires support, whether or not somebody is able to provide consent. So if they determine that someone's able to provide consent, then they would then ask the individual, would you like mom or dad in the room with you? Would you like mom or dad to help you with making a decision regarding treatment? And the individual then has the right to say yes or no. If the healthcare...
We don't have the time to listen. I understand all these gentlemen are quite informed, and often in hospitals, they don't have the time to listen to a normal person say something. So my concern is, how do they know the difference between my son, who can't communicate except with a device, but he's not on the intellectual level to do anything except for, I want to go to the store, I want to eat this. He's not going to understand the power of attorney, or do you want your parent to be here? He doesn't have that capacity.
Well, those would all be signs that the individual may require support, right? So the healthcare practitioner, I mean, I understand that, a lot of times the healthcare practitioner themselves may not be up to speed on what the law says, and usually, and this is more anecdotal, but usually they sort of lean towards letting mom and dad in the room, I found at least, rather than ensuring that the person's rights are respected. But they've got a professional obligation when any of us walk into a doctor's office or into a hospital to assess whether or not we're capable of providing consent. If we're not capable of providing consent, they are very quick to identify somebody because it speaks to, essentially their liability if they're accepting consent from somebody who doesn't meet that test of capacity. Yeah.
As a parent, how can I walk into Shoppers Drug Mart and ask for a printout of the 2013 medical expenses? What kind of document do I have to give the pharmacist to allow me to receive that information without having a power of attorney in place?
Well, there's no way for the pharmacist to know whether or not your son or your daughter has provided you with that consent, right? So if I'm the pharmacist, I'm not going to print that out because I may be in violation of all sorts of privacy legislation and everything else. So I would need to hear from your son or your daughter that that is permissible, you know, even arguably a power of attorney wouldn't provide you with that authority, because again, even if a power of attorney document's in place, step one is always determining whether or not the person's capable first.
It's just, there's so much to do. There are so many forms and government things, and fill this out. And the children, or they're not children, like young adults, they don't have the appreciation for answering those questions and keeping up with everything. So it makes it so difficult for a parent to help them without having a kind of document that allows them to do so.
Yeah, and I mean, we're talking about sort of conflicting rights here, and I understand where you're coming from, and I'm a family member myself, and I understand that you do hit some obstacles and there are some frustrations out there, but we have to be careful not to generalize. We have to be careful, you know, not to say that everybody, you know, is incapable of understanding and appreciating, because, you know, really the ability to do so does vary from person to person. And I think, you know, I think we have to come from a standpoint of saying, okay, we all require support. It's just sort of different levels of support, and how much support do we need. So, you know, you will run into situations where, you know, you're trying to access records at a pharmacy, and maybe legitimately your son or your daughter may require support when it comes to deciding whether or not they're going to allow you to do that. You know, in those situations, I think the best thing that you can do, if at all possible, from a logistical standpoint, is you know, have your son or your daughter there with you, have your child there with you, and if they're agreeable to the list being printed out, then you know, you shouldn't have a problem.
Just time. It's a time problem.
Yeah.
But doesn't the power of attorney is in effect when someone is deemed incompetent? Because in the case of this lady here, wouldn't then her son be deemed incompetent because he cannot make decisions for himself, and then she can then
So I'm going to take a step back, and maybe here's where I should have started.
Oh, sorry.
There is no sort of global finding of incapacity or incompetency, or there's no global finding. So, you know, we sort of, you know, there are different capacity tests for all sorts of different things. So, you know, consenting to health care, opening a bank account, getting married, signing a contract, making a will, they're all different tests. There is a general theme here in all of those tests related to the ability to understand the information relevant to making the decision, and then appreciating the consequences of that decision. There's a test when it comes to whether or not somebody's capable of making a power of attorney. So not everybody is able to make a power of attorney, okay? If someone is capable of making a power of attorney, that doesn't automatically mean that they're incapable of doing anything else. So as soon as I put a power of attorney in place, it doesn't mean that my rights are gone to make my own decision. When a power of attorney in place, step one always has to be whoever the authority is that's looking for consent or looking for a decision to be made, that person always has to determine or you know, whether or not the person is capable of making that decision. So, you know, a parent walking into a doctor's office and saying, I've got power of attorney, I want to access medical records, isn't entitled to those medical records unless the person disclosing the medical records is certain that the individual is incapable of providing consent themselves. In some cases, if the person requires support and would be deemed incapable of providing consent, they may not be able to make a power of attorney either, right? Because they wouldn't meet that sort of legislative threshold of needed to grant power of attorney. So then we would go down to the next step, right? Skipping the consent capacity board again. We'd go down to the next step, and family members are on the list. Family members are able to access medical records, to consent to healthcare treatments, just by virtue of the law that's out there. that says if a person requires support, doesn't meet the test of understanding and appreciating, then I as a family member could step in when it comes to healthcare matters. Okay, is that clear?
But see, now we know that. But when we go somewhere to say a pharmacy, somebody else give me some other examples. Leslie or public health or go to respite, they want to list of their medications, updated. So if I have to go out and get that, I don't have the time, I don't get the respite because I gotta run around and get all the prep work because
for one
night, rest.
and you gotta go to work.
Yeah, and I work, yeah, exactly.
I brought my son to renew his COVID card.
Yeah.
They asked me if he could sign. First I said no, and then they wouldn't allow me to do it. So I said, okay, yes. So I got him over and he signed it. But he doesn't understand what he's signing.
Sure.
So
I think we're all understanding that that the law that's out there doesn't work, right? I mean, and I'm not going to hide that. But a couple of points on that, and we have to be very careful how we address that and what we're advocating for, right? There's sort of two trains of thought. One is that we've got to make this whole substitute decision-making process and guardianship process easier. The other is a much more progressive, and I'd argue enlightened train of thought, which says we have to respect everybody's rights, and we need our legislative frameworks, we need our laws to recognize what we call supported decision-making, or personal networks or family members to help people get to a point where they can provide consent or make a decision. So, you know, right now we've got this substitute decision-making framework in Ontario. We are, you know, advocates in the community are very anxious to move towards this supported decision-making framework that would respect the rights of everybody while providing their support networks, their family members with an easier means to support them in terms of the provision of consent, in terms of accessing records, in terms of renewing health cards. So that's the direction that we'd like to go, and I was going to sort of save this to the end, but if you are at all interested in sharing stories or getting involved in the law reform effort, the timing is very good because the Law Commission of Ontario has an ongoing project right now with regards to decision-making rights and capacity for individuals with disabilities here in the province. So it's a multi-year project. They're about a year and a half into it. If you want any further information on it, I sit on the advisory committee for the project, and the idea here is to have a look at decision-making laws, you know, identify what the problems are, and try to move things forward. I don't know if Community Living Toronto hosted a focus group for this project. I don't know if anybody in the room would know that, but about 30 focus groups are being held around the province. The LCO, the Law Commission, is encouraging written submissions from anybody on this topic. I believe the written submissions were due last week, but they're usually kind of flexible in sort of receiving feedback. And there's also a questionnaire related to this topic that's being circulated to anybody that wants to fill one out. So I encourage you as family members, I encourage you as self-advocates to get involved in that project, because, you know, this area is sort of this area of the law is under a microscope right now, and alternatives are really being explored. Yes, Don?
Can you give us that information and we'll post it on Connectability?
Sure, I will. Yeah, absolutely. Yes.
Brendon, under what circumstances in your practice would you recommend to a family that they take the big step, make the application to the courts to secure a decision granting them guardianship of their adult children?
I mean, we consult on this on a daily basis with families, and our bias is usually towards encouraging them not to go the guardianship route and sort of explaining the law as it stands, and what sort of rights, you know, the individuals have, what sort of rights the parents have, and, you know, really asking the question, why do you require this? Why do you require guardianship? You know, a lot of times we'll have families walk in where their son or their daughter's 35 or 36, and I'll say, well, have you had any problems since the person turned 16? And they'll say no, and I'll say, well, why do you want guardianship? And the typical response is because, well, we're planning for a scenario where we've passed on, and we're not there to provide support and to make decisions. And I say, well, if that's the case, even if you have guardianship, you can't pass it on, right? So you go through this process, the person's found incapable, you know, go through this formal capacity assessment, all the person's rights are taken away, they're given to you, you've spent $10,000 by the time you're done, and you can't pass it on. Situations where, you know, we have pursued a guardianship application is where, you know, families are adamant that they don't want to have to encounter the challenges when health cards are being renewed, or, you know, a list of prescription drugs needs to be printed out, and they don't have the time, they've run into this scenario, you know, on numerous occasions, and they just want a piece of paper, they want, you know, something that's ironclad that says I've got decision-making rights over my son or my daughter. And usually, well, I shouldn't say that, but that's usually the case. Other situations are where you know, we found that there's been a marriage breakdown, parents have split up, and there's a bit of a challenge in terms of you know, mom and dad, or, you know, both parents may not see eye to eye on decision-making in terms of where the person is going to live, and, you know, where to open the bank accounts and everything else, and so a battle ensues. Anytime you've got a guardianship application that is opposed, so where there are multiple guardians applying, not together, but against each other to become guardian, I mean, you've got to, and we don't do this work because we don't get involved in the litigation side of things, but I mean, you've got to mortgage your house to pay the legal fees, because the costs get out of control fairly quickly.
So you don't have a simple answer to her question on how can we be prepared, because we don't like hit the wall with the person there.
Especially when you line your all.
Yeah.
A simple answer to what?
To the question of what can we do as parents if guardianship is not going to help, it costs $10,000. What can we do?
Well, I'm not saying guardianship's not going to help. I mean, if that's I mean, a guardianship is a court order saying that I now have decision-making rights. So
you can have a blue piece of paper. Because most people are not going to have time to assess your situation and then say, oh, come back with your child, or adult, sorry.
So I don't know, what's the particular scenario here?
What is everybody's solution to our problems of going to multiple different places and finding that they need to know that you have the decision? Guardianship?
But again, it depends on what decision has to be made and who you're dealing with. Because there are different rules, and there are different processes, and there are different instruments that may help, right? Like, again, walking into a doctor's office, you don't need anything.
No, because they're there, but I need to go to many places when it's not taking them there, because I have twins, so taking one or the other or both anywhere is impossible.
Right.
Can I ask, is it possible you got a letter from the doctor? Would that be okay? Or would that be, you got a letter from the doctor, you go to the pharmacy, you say, you know, my son has trouble with this, you know.
It may or may not, like I couldn't say, you know, it may or may not, help. I mean, legally, it doesn't really carry any weight, but the pharmacy, practically, the pharmacist may respect the letter. Yes. Yes.
Oh, so you were talking about the hierarchy of caregivers, because you're saying we can choose to go to the power of attorney route, but it may not be necessary. So again, many of us thinking about when we're gone. So
I'm just going to stop you there for 1 second, and then I'll let you complete the second, because I just want to make sure the terminology is being used correctly. So it's not that you may go the power of attorney route. The power of attorney is something that only I can give for myself. So nobody can put a power of attorney in place for me. I think what you meant to say possibly was you may go the guardianship route.
sorry.
Right, okay, yeah.
So I guess I'm just thinking about siblings, right? Because many of us are concerned, we're aging. So some of us may be in a situation where there's a sibling who's more than willing to step up to the plate when we can no longer support our loved one. Again, you said so much, and I may say it, wrong, so please correct. But so again, that sibling could step in, and as long as things have been going okay. And
yeah. So when it comes to healthcare, and again, this doesn't apply everywhere, right? This doesn't apply, say, to property or going to the bank and that sort of thing. And I'm not sure if I got there. I was going there a while ago, and I don't know if I got there. But with healthcare, the law says, if a person requires support, I mean, they use different terminology, then a substitute can come in and for 10 minutes, okay, provide that support. And here's the order in which people rank.
Yeah.
And siblings are on that list.
Okay.
Yeah, siblings are on that list.
Okay.
Yes.
I was just going to say, is it fair to say that it's somewhat discretionary? So with the example of the pharmacy, could a pharmacist who's been seeing you come in with your adult child for the last 3 years, or a banker that you've been dealing, are they just making essentially an on-the-spot decision saying, oh, I've seen you in here, and Joseph,
I mean, you're thinking about practical solutions,
yeah.
and I think that's what you always have to be thinking about, right? Our practical solutions. So, if you're renewing your son or your daughter's prescription at the same pharmacy month after month, then it may be at the beginning establishing a relationship with that pharmacist, and bringing your son or your daughter in to meet the pharmacist, and either your son or your daughter providing consent to say, my mom or dad's taking care of this for me, or the pharmacist then, seeing that that the individual requires support, and then hopefully on a month-to-month basis, you won't run into any problems.
Or just in advance, I know when we were doing the health card, calling in ahead of time and saying, we're coming in to renew our health card, our son can't tolerate standing in line for 45 minutes for whatever. They may make accommodations at setting the groundwork. I think in any situation, right on the spot, someone's going to fall back on the rules, right? As you say, their livelihood is at risk.
Sure. Brendon? Right.
I ran into this issue before. I was shocked when our son turned 16 and he needed to renew his health card, and I phoned OHIP and said he can't sign and he might not be able to get his picture taken, and you would have thought that I was the first person to ever call OHIP with a child with special needs. I mean, it's OHIP, for goodness sake. I got bounced from person to person to person to person, went 4 trips, 3 trips to the doctor, and then only to be told at the end, you're gonna have to go through this again in 5 years. So, because it's not going to change, and that was by multiple people in the local OHIP office, and they were shaking their heads and rolling their eyes in sympathy for me, but we're like, can't do anything. But I've now since found out that they have a form. I know, it's a form, and we live by forms, but there's a form. You go to the OHIP website, you print it out, do it now. I mean, if your child is renewing their health card anytime soon, you get your doctor to sign it. They don't have to date it. You can date it right before you go, and you take it with you, and then the health card is done apparently like that. So.
Do you have to bring your child with you?
No. So at least that is in place now.
Brendon, there's 2 questions over here. I just want to make sure we get to this one, and you'll be next.
It's not so much a question as sort of explanation. I had an experience where I could not pick up my prescription because I don't drive, and my mom wanted to pick up my prescriptions for me, so I had to go into the pharmacist and sign my signatures saying that I gave my mom the right or the opportunity to pick up my medication for me. So I just wanted to tell other people.
So there's a case where you provided consent, you provided permission for that to happen.
I just wanted to say that a lot of times I've been able to give permission over the phone and it's accepted. And I think sometimes it's a personal relationship with people. So if things aren't working out with one pharmacy, you go somewhere else.
Thank you. Yes?
Hi, I'm a sibling, and I look after my sister, basically 98% of everything. So my wife helps me. I have consent, everyone asks for it. But let's say if I go tomorrow, and my wife Michelle, very nice lady, will take over my role. But she's not being recognized in the
hierarchy, right?
Yeah.
Are there any other family members?
Well, luckily my parents still around. We live together. Having said that, I have talked over the majority of the function over the last 10 years, so it is really me.
Yeah, and you know, you've identified a key gap in the legislation because in-laws are not recognized in the hierarchy. And therefore, I mean, you know, somebody asked us, somebody earlier asked, you know, when would guardianship sort of be a little bit more, I guess, justified? It may be if somebody really does require support and they have absolutely no relatives that are ready and willing to provide that support. So if there's an in-law that wants to provide the support, the hospital may or may not respect that. Legally, they don't have to. And unfortunately, due to the gap in our legislation, that may be an instance where guardianship is the only answer under the current legal frameworks.
Yes, Brendon, I have a question. Say this is like off the topic of healthcare, but it's still like around like trustee and let's say attorney of power. Okay, let's say you had a bank account, right, that had a trustee on it, right, and let's say like the person who was trustee, but the person who was on the account, right, was taking money out. And the trustee didn't know, and the bank was not notifying the trustee that this person was taking money out of the bank account, right? You know, and then they decide to, you know, basically like freeze the account,
right? And
let's say, and not like let the trustee know anything, right? And then, you know, basically like, you know, the trustee then decides to resign. Right, and the bank is saying, oh, well, you know, we need to go through legal department or anything. Is the bank allowed to be going to that when let's say, there was a letter signed by the trustee that says that I'm removing myself as trustee? Is the bank allowed to still go to the legal department, or like can the trustee just write that letter, sign it, and then like give it to the bank? Because you know, like I don't know like a lot of stuff like that.
Sure. So that's sort of a good segue into property, and you know, if you have a bank account set up where there's different types of bank accounts, and if you have one of these bank accounts set up where there's a trustee and there's something called a beneficiary, the person who sort of owns the money. Yeah. Usually, the beneficiary wouldn't be able to withdraw money from the bank account without the trustee's authority. Okay. So I'm not sure how that beneficiary got money out of the account without the trustee signing off on it. But I guess to answer your question, if the trustee can always resign. And
would the bank, let's say the bank like asks for like a note saying, you know, oh, you know, like if she was signing on it, she gives the note, signed it, and say, oh, you know, I'm resigning, right? And the bank still goes to the legal department and is not letting the trustee know what they're doing, because the bank had nothing to do with like legal document in the first place, right?
So I think what the bank will go to their legal department to find out what to do next, because now there's no trustee there.
Okay.
To make decisions regarding that bank account. So that's probably why they're going to their, yeah. I've got 2 minutes, and I'm on my first point, I think. So, maybe what I'll do is very briefly just jump into property. So property doesn't work in the same manner as healthcare. So unfortunately, with property, when it comes to providing support to individuals, it's a lot more difficult in some respects, mainly because in that hierarchy, family members are not identified. Again, I would stress with property, as I do with personal care, if any of us are able to make a power of attorney document, that is the easiest, most cost-effective way, most respectful way as well of having somebody in place to support us. So if I need help, I've got the choice. I execute the power of attorney document, and that takes care of all of these issues. If I can't make a power of attorney document, it becomes a lot more difficult. And unfortunately, the way the legislation is drafted at this point in time is that the only other option is guardianship. That being said, with the majority of our, with some of our families, the individual in terms of income, maybe their sole source of income is ODSP. And if that's the case, we know that there's this ODSP trustee process that is sort of this simple form that is completed at the ODSP office that the individual, by the way, has to sign off on or provide consent to. So if the individual ever raises an issue, if the ODSP recipient ever raises an issue in terms of who their trustee is, ODSP and most, is obligated to investigate and perhaps remove that trusteeship. Secondly, the main asset that many of many of the individuals that we support have is an RDSP, a Registered Disability Savings Plan, and there are issues with the RDSP when it comes to capacity and decision making. But a couple of years ago, parents were sort of added on the list for adult beneficiaries who are wanting to open up a plan. That's a temporary measure that's in place till 2016. But the gap in the legislation regarding the RDSP is also being worked on by the Law Commission of Ontario, and we're hoping that there's a solution in place within the next year or two.
On your comment on the RDSP, so many of us parents, before our child was 18, we opened up an RDSP, the mom or dad, the guardian of that. Child turns 18, letter comes from the bank. What do you do? What changes when the child becomes 18?
So in terms of your plan holdership, nothing changes. Okay, so the law says that if you opened up the plan prior to the beneficiary turning 18, at age 18 nothing changes other than the beneficiary having the option of opting in to be a co-holder or replacing you as plan holder, but your sort of designation as a plan holder continues.
Now what about if the beneficiary, the person you opened the plan for, passes away? Where does the money go? Do we need a will in place?
So if the beneficiary passes away, then any money that the government provided within 10 years of passing goes back to the government. Everything else goes to the beneficiary's estate. So if the beneficiary is able to give a will, that's where a will would come into play. If the beneficiary is not able to give a will, then there's a law that says money goes to family members in a specified order. Yeah. I'm going to close, and because I know I'm about to get the hook. Again, the stories that we heard from the panel were really inspiring and wonderful stories, and I had a list of different laws and different protections that are in place to respect the fact that we all are equal before the law. Our highest law in the land, which is called our Constitution, has protections in there. We've got human rights codes in the province. We've got an international document now with the UN Convention that respects that. So things are becoming a lot more progressive. Obviously, that has to also, the needs of family members and supporters also have to be considered, and that's why I would strongly urge you to get involved in this Law Commission of Ontario process, because that will allow all of your voices to be heard. We have models that work. We have models that work here in Canada. in other provinces, and we'd like to see the law in Ontario move in that direction.
Sorry, can I ask you a really quick question? If there are self-advocates that want to become involved in that, is there a place for a place for them?
Yeah, send me an email and I'll connect you with the right people at the Law Commission. And I know that there have been a few consultations that have been held for self-advocates. I'm not sure if they've all been completed or not. And there may be an opportunity to schedule an additional one with the Law Commission for self-advocates here at the organization.
I'll email.
Yes.
So where do we direct our letters then?
With regards to this project, either send me an email or jump onto the Law Commission's website, the Law Commission of Ontario's website, and you'll see it's probably the project that's right there on their front page, and they'll have all of the information related to the project right there, or they should. If not, send me an email and I can connect you with them. It's called Reforming Ontario's Decision-Making and Capacity Laws, or something along those lines.
Brendon's actually going to give that information to us at Community Living Toronto, and we're going to put it on the Connectability website. So just give us a couple of days and we'll get that information up on Connectability. I also want to remind everybody here that Family Link or Connected Families, if you have information, like I never thought to share about what the OHIP experience was like, but if you have any advice or if you want to get some information or share ideas, then you can use those two vehicles as well. And so I'm going to bring up Jenna Martinuzzi, and she's going to make a little presentation to Brendon.
Thank you, Brendon, for everything that you do. We also appreciate the work that you do. This is our key of our appreciation.